in the beginning, I would like just to mention the topic of this panel. This panel is about the relationship of regulation and competition. And if you ask a competition lawyer about this link or this relationship, he or she would certainly say that regulation should be in line with competition or supporting competition or in conformity with competition. But what does that mean when it comes to practice or to reality? That's our issue this afternoon. Shall regulation substitute competition? Shall regulation simulate competition in the sense that regulation orders market results that would be achieved if there were competition? We have 3 distinguished speakers and later 2 distinguished commentators on these issues, so we have a very full program, and this is the reason why we should start immediately, I think, in order not to waste any more time, and I won't eat much time anymore by talking now. I just want to introduce our first speaker. Our first speaker is Professor Francisco Marcos from Madrid. Professor Marcos holds a law degree from Universidad de Oviedo, a Master of Laws from Berkeley, and a doctorate from the Real Colegio de España in Bologna. He used to be a Director General of Competition Policy at a regional antitrust authority in Spain, but he stepped back from that position 3 years ago, or a little more, and now he is teaching law and economics inter alia at the Instituto de Empresa in Madrid, and I'm very curious about what he has to tell us about preaching with a stick, assessment of competition advocacy in Spain. Professor Marcos, the floor is yours.
I'm not going to talk about regulation. The title of my paper or of my presentation has to do with the experience we have had in the last, I would say, 5 or 6 years in Spain dealing with the topic of this conference, state-favored or state-induced restraints to competition, public restraints to competition. And, the main argument I make in the paper, as I will explain in the next 13 slides, it's not going to be long, so you won't have to suffer much, is that the Competition Commission in Spain deals with the state restraints to competition using 2 hands. On the one hand, it uses, preaching and promoting how good is to insert competition as a principle in the workings of the public bodies, even when they are out of the markets. But since 2007, when we had our last reform of the Competition Act, it also uses a stick, which is something peculiar, although other authorities in other countries have it. The Competition Commission is entitled to challenge in court anti-competitive measures that has been put in place by the state, and I'm going to talk about 2 or 3 cases where it has been done at the end. But in order to provide a framework of the study of the situation in Spain, which, by the way, may look to be something really local or really folklorical, irrelevant for everyone else, I disagree. I think that the problem is major. This problem, state restraints to competition, is something we face in every competition system. And the solution I'm going to talk about we have in Spain is similar to the one other European countries have developed, and even some other South American countries. So I don't think it is, any stupidity to look at the Spanish situation. I think it can provide an example or at least a perspective of how things can be solved. But from a theoretical perspective, I mean, I found something really, really puzzling. I mean, all competition lawyers and mainly economists are very keen of this paragraph of the Wealth of Nations, where Adam Smith talks about how bad are the meetings of business people. When they meet, they always do bad things. What are bad things? They either do cartels or, a kind of concertation, collusion, something bad for the consumer, right? But if you keep reading the paragraph, this is just, it says, as you know, people of the same trade seldom meet together, even for merriment, party, and diversion, but the conversation ends in a conspiracy against the public. Raise prices, restrict output, bad things, as I said. But then Adam Smith also thought about something else when he was talking about, I don't think this works, moves to public restraints. Just in the next line, he starts talking about it is difficult to fight against meetings of business people. There's no way we can prohibit them because, there's in many countries there's a right to reunion and to meet together, and there's no way you could prevent that from happening. But at least, and I think the last sentence of this same paragraph is quite telling. He says that the law ought not to do anything to facilitate such assemblies, and much less to render them necessary. And it is, I think, very, very telling that in the 18th century, Smith was also talking not only about private restraints to competition, but also about public restraints to competition. And indeed, I think in this paragraph, he was sending a powerful message to the state. Fight private restraints to competition. Please do not introduce public restraints to competition, right? Why this should be avoided? I think there are two main reasons. In my opinion, one of the problems we may have if we let this, and I think that's one of the reasons why this is a very important topic. I mean, if we let public restraints to competition, whatever they mean, and I will dip into this in a minute, flourishing, the problem is that we're revealing some, or probably the major weakness of the competition law or the competition policy system, which is, a fragile point where the Achilles heel of the defense competition, where probably, I mean, if I'm a business person and I'm trying to arrange a cartel, but I risk the authority from, punishing me, what I can do is I go to the state, ask the state to enact the cartel within a legal instrument, and I'm saved. It's a major trick, but that is not a surprise that in some places we've seen that happening, right? And I think it also has a very relevant meaning regarding how relevant or how important may be law enforcement, either public or private. All these things we talk lawyers conferences, how relevant may be, for example, to promote private enforcement in Europe. But the thing is that there's no point in promoting public enforcement or private enforcement if we still allow public restraints to competition to prosper, because then, I mean, this reveals a really contradictory message regarding what's the attitude of the state regarding markets, regarding competition, and regarding freedom of businesses, right? So I think this is, as I was mentioned before by several of the speakers, a very relevant topic. In my presentation, I'm going to talk about this, a little bit about the concept and relevance of public restraints to competition or state-initiated restraints, as I will just make the point. I think there's a problem of terminology here. There are many things among the same, which are covered in the same term of state-initiated restraints to competition, but nevertheless, whatever we mean, I think this is relevant to solve from a competition policy perspective. And then I will get into the Spanish system as an example of how we deal with this in Spain, but the lesson probably is similar to other European countries because at least European Union law is very relevant regarding how we solve some of the state-initiated restraints in Spain, right? First of all, this, what are state-initiated restraints to competition, is state-promoted or state-favored restraints to competition? I think there are two major things covered among this concept. The first one would be probably under the heading of what Daniel mentioned initially. There are, in many occasions, rules, actions, or decisions by the state, by public bodies, that directly restrict competition. Regulation is probably the major one, but that's only one of them. People here have mentioned before state-owned companies. State aid also is a major area of relevance. And also the rendering of public services by the state, of course, it has an impact in competition, and in some cases, and in some countries, the impact is really huge because there's, for example, a public monopoly and there's nothing else. And there are also other things which are difficult to classify, which are, situations in the market where the public body is involved and you don't really know. I'm going to provide an example at the end of a situation in Spain, what the public body is doing there. I mean, what is, for example, a Director General of Agriculture doing in a meeting of the cartel for the grapes somewhere? And this is something we have faced in Spain in the last years, right? So in this first group of practices, what we would see is that the main characterization is that no direct action by the firms is required. The restraint comes directly from the action, the rule, or the decision of the state. That doesn't need to be acted upon by the private parties. And this is, as I said, one group of restraints or with origin in the state. The other group, which is the one to which I have devoted most of my research, and I have at least 4 or 5 papers that deals with this. You can find them if you are interested in the social science research network in the web, has to do with those rules that provide the framework or the decisions of the public bodies that provide the framework where the restraint may occur, but they need to be acted upon by the private parties. And in some cases what happens is that the rules force the private parties to restrain competition, promote it, but doesn't force it, or favor it. But again, we need the market players to do something. I mean, it's not enough with the state action to occur. I mean, if we talk about how relevant these state-initiated restraints may be, well, I think this is, the relevance is huge. I mean, I remember, and I don't know how to put it, but I think probably state restraints to competition are there present in the market at the beginning of any competition system. But the problem we face is that the awareness of them only starts once the system is a little bit mature, and it has been settled for a while, right? I think I have just read a very interesting Italian book that talks about the antitrust seasons, La stagione dell'antitrust. And the book talks about, the competition systems goes through seasons. Of course, we start by spring, summer, autumn, and winter. And I think in order to be worried about antitrust state action restraints and all these kind of practices, you need to be well advanced in the seasons. It needs to be probably either end of summer or autumn. So normally, when we're talking about establishing a competition law regime in developing countries, we don't have this in mind, although probably it is there. And one of the nice things for researchers, but probably less nice from practice, is that this worldwide phenomenon provides, and I think this is a topic that, or an idea that has been raised by some of the commentators before, a worldwide phenomenon that has different shapes and contours in different jurisdictions. The profile of how this works is different in each country. Like, for example, we could see that the original case of Parker versus Brown, which is the origin of a state action doctrine in the US, was a case of a restraint to competition in the commerce of grapes in California. And nowadays we are facing the same situation in the Jerez grapes in Spain. But of course, culture, institutions are different. But the problem is more or less the same. And I think it's a problem that has somehow raised an interest in the literature in the last 4 or 5 years. There has been people doing research on this area for a while. But in the last 4 or 5 years, we have seen in Europe, in the US, and worldwide, several relevant papers. I cite some of them there. But, you know, Herb Hovenkamp, who is also very productive, I think 2 weeks ago, has a recent paper on this. So this is a hot topic. And not only in the US, also in Europe, of course, how we deal with it is completely different in each country, but the problem in itself is a similar one. And I think we need to do something with it. Because, I mean, if I take this paragraph from the article that the former chairman of the Federal Trade Commission, Tim Morris, wrote some years ago, and this deals with the trick idea I was mentioning before, either we deal with state restraints to competition in some manner, or the problem is that we're going to face a situation in which, as he says there, rational firms are likely to prefer public governmental restraints. And, you know, what they do is they fight for them, they lobby, they do whatever they need in order to have their private restraint to be contained in a law or in a decision of the public bodies. And, of course, this is the most efficient way of being anti-competitive. So I think the question is crucial for the effectiveness of the competition system. How do we deal with this in Spain? Well, first, we have to look at European law. Why? Spain is, since many years, member of the European Union. And I think the rule here probably is similar to other European countries, of course. The first idea is we look at EU law in Spain especially from the competition perspective, whenever trade between member states is affected or is appreciably affected. And there's a doctrine by the European Commission of what this means. So this means that all those public restraints that do not affect trade among member states or between member states would not be covered by EU law, or at least EU competition law. There's a caveat on this, which is the interpretation by the European Court of Justice of what does it mean to affect trade between member states is very wide. Some conducts that are purely local have, in the case law of the European Court of Justice and in the practice of the decision, be understood to restrain trade between member states. So single member state conduct may be covered also by European Union rules. Apart from that, as I will explain at the end of my presentation in just a few slides, you will see that we also have local domestic rules, but the European rules are the first ones we need to look at. And when we look at the European rules, the main idea here is not only competition law is relevant. We also need to look at something that was mentioned before by some of the speakers. The free movement, the freedom of establishment is relevant because when we talk about actions of member states that restrain trade, in a sense, we are doing something that goes against the treaties. And thus, despite the change we have had in the Treaty of Lisbon that has taken the competition policy as an objective in the treaty but has put it in a protocol, it's still there. And member states are not supposed to game the system in allowing or forcing actions that would go against the union's objectives. One of them is to have a competitive market system, right? So not only competition law is relevant, when we talk about things which are not competition law, like freedom of movement or freedom of establishment, the problem we have there is that there are exceptions to what the member states cannot do. And as we have seen in the case law of the European Court of Justice, well, there are many occasions in which member states have been allowed to establish clear restraints to competition on the basis of the public interest, and so there may be I don't know how big, but a loophole here. When we talk about, and I'm not going to stand on this because I'm neither an expert nor I have time to talk about it. We also have in competition law some tools that deals with state action. I think we've heard something today. We will hear a little bit more later and tomorrow. We have Article 106 of the Treaty of the Founding of the European Union that talks about the situations in which we have state monopolies or services of public general interest. Very problematic, but there's I would say a solid practice by the Commission there, and also the Articles 107, 109 that deals with the state aid, which I mean, think about it. It's the major form of restraint. I mean, even politicians, we all agree that politicians are there to give money. That's the job, but the problem is that may distort competition. My final ideas of what is the rule in Spain, and I think I've seen this in similar terms in other European countries, and some Latin American countries may have included a similar provision in their Competition Act. What we have in Spain is a major exemption to state action which is covered by an act of the legislature. So the idea here, and I think I was just looking at one book here in Brazil. The rule may be similar, although I haven't been able to find it in the Brazilian Act directly, expressed. The idea here is that if you have a restraint to competition which is contained in an act approved by the Parliament, end of the question, you cannot do anything else. Why? Because the sovereign has decided that another value different from competition is preferable in that area. The tricky part comes later when we talk about those situations in which we do not have legislative support for the restraint, but nevertheless, it's happening there. And we have in the Article 4, Paragraph 2 of the Spanish Act, that the prohibitions, that means the cartel prohibition, the prohibition of abuse of dominant position, applies to situations restricting competition which are derived from the exercise of other administrative powers or are caused by the action of public authorities or public companies without legal protection. So first, formal text, do we have a law? It is covered in the law. I mean, there's a huge case law in Spain that what does it mean to be mentioned in the law? Because one of the problems, it is stupid, but one of the problems we faced 20 years ago is that people were saying, as we have a freedom of agreement rule in the civil code, this may mean that there's a cartel exemption there. No, it needs to be a clear legislative mandate which makes express the willing of the legislature to preempt competition and put another public interest in place. How does this work in practice? Because the second paragraph, as I said before, is very problematic. When we have legal exemption, there's nothing you can do. When we have conducts of the public bodies that take place in the state, there's an economic activity. The rule is clear-cut, and what we do is we apply the rule to acts of the ministries or the public bodies that buy or sell stuff in the market. Although this is problematic because something mentioned by Professor Drexel before, this Venim case I think is a major disaster, but I don't have time to look about that. And then the real and the crucial, the essential point comes to decide what do we do with those cases in which we have really public authorities or public bodies not acting as undertakings but acting or developing or rendering public tasks. What do we do in those cases? So, and that's where the idea of my paper comes. What does the competition commission does in those cases, which are many? Well, first, we have seen in the last few years a surge in the number of reports, guidelines, promotion efforts that had to do with telling the public bodies how relevant is to take competition into account and do not distort competition when they act or regulate the markets. And this also is relevant regarding competitive impact assessment. Due to some laws approved in Spain some years ago, and forced in part by the European Union, we need to make a preliminary competition impact assessment of every new regulation which is enacted. This is also a venue through which the Competition Commission is making public bodies aware of how relevant competition may be. And the stick comes where we see the National Competition Commission being awarded the legal power to go into court and challenge regulations or actions without legal support that restrain competition. And legally, this may be just a provision like anywhere else, but I think it's very relevant from the meaning perspective, because we're talking about an administrative organ, which is the Commission, that goes to court to sue another organ, probably in some cases of the same administration. In Spain, we have a decentralized system, so it may also be the administration of a region or whatever. And we have seen in the last, and this is my last slide, and I will close with these two ideas. In the last few years, the Competition Commission using this in three occasions. Two of them had to do with regional authorities, and two of them had to do with bus transportation for passengers in regional routes. There's a European Union regulation in 2007 that wants to make competition the most relevant principle in the area. What we see in this case is how the regions acted just a few days before the regulation was entered into force in order to extend for many, many years the contracts of the current providers and shield them from competition. This has been attacked in court. And then the other one is just, I think 1 or 2 weeks ago, has to do with Endesa, major electricity provider in Spain, owned by Italy, but by the Italian firm Enel, but that has been punished many times by the by the Spanish Competition Commission for abuse of dominant position, and it has done just what the chairman Mouris said. They were, I think, punished 2 months ago because they were doing something in one market that they were not allowed. They have managed for the Ministry of Energy to place the restriction within the rule. And so the Spanish Competition Commission is challenging the rule in court. But it hasn't been easy because, of course, politically it's very controversial. And I'll close with this case that I find really amazing. It has to do with one of the, and it's very, very illustrative of a cartel. I mean, one of the last cartels we have discovered in Spain, mainly because leniency had to do with sherry, the sherry wine. And it was not just one cartel. There were 3 or 4 cartels together in which they were fixing everything. Everything. They were fixing the amount of sherry they were sending to the market, output limitation and market sharing. They were also, I didn't know, but you know, most of the sherry drunk by the British is bottled by the British themselves. So it is sent them, and the supermarkets, the big supermarket chains in Tesco and all these chains in the UK, bottle the sherry that receive in big tanks. And so this amount of sherry was also, the price of that sherry was fixed. And the final cartel that I want to mention, and I will close with this, had to do with a cartel in which the price of the grapes and of the sherry must, with which the sherry wine is made, was fixed by both the grape makers and the wineries. And the thing here is that in the meetings of the cartel that was developed in a period of 5, 6 years, the Director General of Agriculture was present. And he was, you know, promoting the cartel. Indeed, somehow, and even though it was clear-cut that there was a prohibition, it was the regional Ministry of Agriculture, the one in charge of monitoring behavior that is, you know, departed from what the cartel prescribed. The Spanish Competition Commission has made a very nice, and in my opinion, stupid decision in which they have decided that this could not continue. And so they decided, even though they cannot do it, because they cannot apply, in my opinion, the competition law to a ministry which exercising, or probably mis-exercising, his power sitting in the cartel meeting, they have convicted the ministry as a cartel facilitator, using the EU doctrine in the case Trojan. I don't think he's a facilitator, and I think the Competition Commission is using the wrong tool in this area. There's something, at least in Spain, but I think in other countries as well, which is called criminal law, which is perfect. I mean, when you have something that probably, I don't know the guy, and I don't know the circumstances in which the ministry was sitting there in those cartel meetings, but definitely he was, you know, I think crossing the red line to commit a crime, and probably what the Commission should have done in this case is just send the papers to the public attorney for starting a criminal case. Thanks.
I hope we have time after the speeches and the comments to discuss jointly the different presentations. I'm very happy to introduce now as our second speaker our dear ASCOLA colleague, Professor Paul Nihoul. Paul pursued not only legal studies, but before that also language studies. He earned afterwards a doctorate in law. He holds inter alia a Master of Laws degree of Harvard University, and he has carried out many positions in academia and beyond. Let me just mention two things. The one is that he was for several years a référendaire, which means something like a law clerk to famous judges at the European Court of Justice. And currently he is inter alia editor of the Journal of European Competition Law and Practice. So much to his presentation. Today he is speaking to us about the concept of universal service. Paul, the floor is yours.
To these students, I would like to convey a message of friendship. There are many young, promising students in Africa, Europe, America, Asia, all willing to work with you to build a better world. So I can only encourage you to travel, to visit Belgium or other regions, and to study there and to work there. As we are among friends here, as I understand, I thought that I could start my presentation with this. Did you say? I need to push?
Oh, you need to point it.
I need to point it.
Yeah.
This. Now, this is an astonishing and fascinating painting by a early 20th century painter, Theo van Doesburg, normally exhibited at the MoMA in New York City, but now currently on display in Beaubourg in France, Paris. As always with this kind of painter, I guess part of the trick is to try to see what he was trying to represent. So is this, for instance, soccer player running on a field after the ball? Or maybe students scrambling just before exams? But in this case, the painter gave us some clues because he left with us some drawings in order to help us understand the process of composition of this painting. like this one, for instance. You probably see 2 legs, 2 arms, a head. And from the context, which you don't have here, we can understand that it's about a Russian dancer. And this one afterwards, another one. And this one again. So you see, the painter has followed a process of abstraction whereby he's showing us that he's not so much concerned with the provision of a faithful picture-like representation of what dancing is all about in Russia. He's rather concerned with the representation of what, in his view, makes the very peculiarity of this dance, its essence, its structure, or, as he will say, its rhythm. Why am I talking about this here? Well, because I think that what Theo van Doesburg has done for Russian dancing, we can do this too, for antitrust. We can take a topic, in my case, universal service, and we can try to dig further and further, deeper and deeper into what we consider to be the essence of what this concept is about. So, it all starts with the notion of public service. As you know, public service was a notion traditional in many countries, particularly European, continental Europe, and also in all the countries influenced by French law or German law or Roman law. And public service is about the organization by authorities of entire sectors of the economy for several reasons. Maybe because there was no capital, private capital available. Or maybe because the public authorities wanted to equip the land with basic infrastructure, like telecommunications or distribution of energy or railroads. Or maybe because the state and those occupying the positions of power in the state wanted to get a grip on resources. What are we going to say about public service? I don't think you're concerned here with technicalities of what we can find in Europe. I have put a reference of a book I have written with Peter Rodford on this, on electronic communications, for instance, the concept of public service there. What I would like to think about with you is about the underlying reasoning. There are, in fact, 4 steps, even though we have only 3 mentioned there. The first one is that some services are considered essential in given societies. The second one, as those services are essential, it is deemed that all members of society should have reasonable access to it. But there comes the trick, because if we let those services be provided by private actors, what is it going to happen? They are going to concentrate on the lucrative segments of the market, i.e. provide services to the rich people. They won't care about the rest. Yet, we want the services to be available to all. So, the approach goes, we have to let the state, public authorities, provide the services. Now, this is a first description. Now, let's go to the toolkit in order to try to dig further and further. One of the interesting research developments in the last decades is the research about the concept of narratives. Very useful in law, in fact, because it is possible to consider that each legal production of document or text constitutes nothing else than a text, i.e. a story. You can tell a story about the universal service. Once upon a time, in a given society, there were people considering that some services were essential, etc., etc., etc. This approach has been developed particularly in France, where literature is so important, as you know, but it is also known and trendy in other places of the world, including the United States. I'm more interested by the second one, actually, the concept of grammar. Generative grammar, in particular, which has been developed by Chomsky, a linguist applying the tools of mathematics to language studies. So what was he saying? He was saying basically that all of our sentences, what I'm saying now, is being generated from a basic set of principles which are put into interaction. And we see that when it comes to law, legal regimes or legal systems are nothing else than propositions that we have to logically articulate with one another. Let's make the exercise. Let's go back to the 4 elements that we had mentioned before. We start with the upper one. Some services are essential. Then we have a causality. As they are essential, they have to be provided be provided to all members of society. Then we have another kind of principle stating that, based on the representation of economic actors, and stating that private actors won't do the job properly. And the consequence, once more, is that it should be left to public actors. If we could try to take one of these sentences, like for instance, the very first one, or the second one, all members of society must have access to essential services. We see that that sentence can be based on more basic principles, like the fact, for instance, that in a given society there is a desire to avoid social divide. You would have social divide if you have people having access to the internet and other people having no access. It's not good for social cohesion. You could have people thinking on the basis of economics that we ought to let the best people emerge in society, not just to continue providing the same advantages to all those who have already those advantages, already have access to the internet on the basis of their wealth. We have to provide access to those people who don't have that access, because through that mechanism, maybe we will allow more intelligent people to come up and to come out of the crowd. And then on another level, we see that we also have consequences, i.e., if you want the services to be made accessible to all, that means that, as we have said, that the service has to be organized by the state. And what form is that going to take? First, you want to entrust a public body with this. Second, you want that public body to act according to instructions given by the state. You want to have people appointed by the government on the board, and you want to give a monopoly. Here we are. Not on the non-lucrative end of the market, because we don't need a monopoly there. Nobody is going to take care of that anyway. But a monopoly on the lucrative part of those services in order to raise revenues, which will be used to cross-subsidize the services provided at a loss. This is the public service. Lots of success for almost a century, but now under attack. Sorry, I'm also under attack by three different angles. The first one being Chicago, no surprise. So what do they say? Again, if we try to see the structure of their reasoning, they say that society must pursue efficiency, and that if we want to have efficiency, we need to have freedom on markets. And as a result, because monopolies are just the opposite of freedom, that we want to do away with legal monopolies. That's the first angle of attack. Another one, interestingly enough, is the European integration narrative. Look at this. What do they say? We have to unite, we say in Europe. The result of this is that we have actually to eliminate all barriers established by member states and constituting impediments to free movement on our territory. And the result of this is that we ought to do away with legal monopolies because they are fragmenting the market in the same way as borders used to do. So you see, interestingly enough, we have divergences in goals. One is efficiency-oriented. The other one is, you could say, social-oriented. We want to unite the people. Isn't that a nice narrative? Isn't that a nice story? But you have similarities and convergencies in the methods. The one says that markets are efficient when they are free, and the second one says that, well, European integration will come through markets freed from national interventions. And you also have convergencing regarding consequences. And the consequence in both settings is that legal monopolies should be eliminated. Now, this is extremely powerful. The combination is extremely powerful. There is an hesitation in European law. On the one hand, you have some documents stating that we ought to consider the internal market first in all circumstances, like the first liberalization directives in electronic communications. It states that we have to provide consumers in Belgium or in France or in Germany with a chance to have access to equipment or services provided by people established in the UK or in Spain or in Italy. See? But in other texts like Mercy, which is an important judgment from 1993, if I'm not mistaken, now I'm doubting, actually 91 or 93, stating that in the context of legal monopolies provided to people in charge of handling products in ports, in harbors, stating that those monopolies cannot be maintained because prices are too high, quality is bad, there is no use of new technology, innovation, etc. That is actually what in competition in general, in literature concerning competition, we say about the disaster that monopolies can bring to our society. So there is an ambiguity, but that's a very powerful combination because suppose that one person in the room would say to a commissioner, a member of the European Commission, you guys are only interested and care only about efficiency. Can you not care about the people? But it's easy to respond. We are caring about you guys. We are doing Europe for you. So why are you saying this? You see? The combination of these two narratives is extremely powerful, particularly because it is also reinforced by another one, a third one. Let's call it the Doha narrative, in which multilateral trade agreements are negotiated, and where it is said, basically along the same lines, that prosperity will come through international commerce and the dismantling of trade barriers. So we have a tax on the traditional grammar concerning the public service. What is going to happen? Who's going to win? Who's going to lose? Do we have to have a negotiation? Well, in this case, there was a negotiation. There was a negotiation on the kind of narrative that would be proposed to the people. Interestingly enough, actually, around the concept of universal service. And you see, the new grammar takes elements from the traditional one and the new perspectives in Chicago, Brussels, and Doha, i.e., the first proposition is taken from public service conception. Services are essential and must be made available to everybody. And then we shift to the second one, actually, to the other perspective. in order to reach that result, we have to take the other approach, the Chicago, Brussels, Doha approach, i.e. let the markets play freely. That doesn't say, so that's the concession by free market people in Europe and other countries as well. That doesn't say that public authorities have no role any longer. I can reassure you, would say the commissioner, if he was talked to by people reproaching this kind of efficiency-based narrative. Authorities still have a role to play. But then again, one concession to free market people, well, they have a role to play, but it is going to be limited. You always have to choose the least distorting measure, and you have to respect equality among players. So here we are now with this new concept, this new grammar about the universal service, bridging gaps, in fact, between disciplines or across disciplines, because law, particularly in continental Europe, was associated much with the traditional public service discourse, whereas economics was more associated with the efficiency narrative. It is bridging a gap between these two narratives or disciplines. Across continents, because we Europeans, have adopted a concept which was already in use in the US, and through conferences, personal contacts, official contacts, we are also exporting this new narrative to various countries. I was reading that the notion of universal service is very popular in Brazil regarding telecommunications as well. And we're doing this across sectors. We know those sectors traditionally concerned with universal service, telecom, energy, railroad, etc. But other sectors, all sectors in which providing essential services to society is concerned, all sectors can be organizing along these lines. Even us, even universities. Are we not providing a service which is essential to society? And should that service not be available to most of us? That's at least the story, the narrative in Europe. Well, yes, we should. So are we going to use the universal service type organization in order to ensure the provision of those services everywhere? Well, interestingly enough, not everywhere. In Spain, I was talking to my colleague yesterday. He was telling me that there are restrictions on what private companies can do if they want to establish a university. And closer to me, very recently there has been a project by the public authorities to grant a public monopoly to universities, a geographic public monopoly to universities in specific zones, excluding all other universities, excluding the provision of service in that zone by universities that will be located elsewhere, and providing also special rights, in technical terms, special rights to those universities present in the zone, i.e. particularly to the biggest ones who would prevail in case several universities are within a zone. They would prevail as to the kind of teaching program that would have to be provided in the zone, or also a special right to the extent that universities principally settled in one zone would prevail when there are negotiations about the coordination of activities. So you see, universal service is on its way to become itself a universal grammar or concept, but we're not quite yet there. It's a question of change. We have to convince not only lawmakers, but also society. And there are three rules that we have to remember coming from theories of change and theories of innovation. First, dissemination is really essential. Second, if you want to disseminate, you have to innovate at the margin, i.e. you have to take as a basis traditional conceptions and move them slowly into new areas. And third one, you you have to respect the rhythm of the people.
Taking into consideration time issues, I think we just go on, and I would like to present our third speaker this afternoon, Mr. Gesner José de Oliveira Filho. Mr. Oliveira Filho is a former president of the Brazilian Competition Authority of CADE, where he served from 1996 to 2000. Today he is a partner with GO Associados, and in between those two occupations he served as CEO of an important supplier of the basic sanitation company of the state of Sao Paulo, which is the water supplier for this whole region. And taking all these three occupations together makes Mr. Oliveira Filho the ideal speaker for our next topic, which is the competition dimension of the Brazilian regulation of water infrastructure. Mr. Oliveira Filho, we are happy to have you here. The floor is yours.
I consider myself to be very privileged to listen to the previous presentations, very, very interesting presentations. And I think that what I can do here, Mr. Chairman, is to illustrate some of the problems, some of the competition problems which occur when we have a market which is a regulated market. And what's interesting about this market, we are talking about the water industry and sanitation. What it's interesting that it is a market that is considered to be a public service, and also something very essential for society, and has a great impact upon health, as we are going to see. I will illustrate some problems which are surprising for someone who works with competition policy. I myself worked for many years with competition policy and became the CEO of a water company. And so I, all of a sudden, after many years of fighting monopolies, I became the head of a monopoly. And it's interesting that some new insights can be perceived if we see how public companies compete in a regulated market. So I hope that these illustrations will help the discussion, which, as I said before, is very, very interesting and crucial for the stage that many Latin American countries are at this moment, in Brazil in particular. So we are going to see 3 points. First, I will take the liberty to tell you a little bit about sanitation sector in Brazil, just to give the background information. Second, I will also tell you a little bit about regulatory aspects of the sector, because I think that they illustrate something that poses several difficulties in terms of having different levels of government in a relatively complex federation like Brazil. You have different types of government in different types of regulatory bodies, and they have jurisdiction on topics that competition agencies also have jurisdiction. So I think that that poses some interesting questions. And finally, I will bring some competition aspects that can be discussed in the water and sanitation sector, and illustrate some of the peculiarities of regulated markets, and also peculiarities of emerging economies. In particular, I would like to call your attention to informal markets, which change the dynamics of competition of markets in general and also regulated markets. So let me tell you first about water in Brazil. If you read Brazilian papers, you will immediately see several news about the disaster of water and sanitation in Brazil in many, many regions of the country. I will give you some numbers. More than half of the Brazilian population do not have access to wastewater collection. So this is a big health problem for the country. So universal service in this area is particularly important. So somehow we have to have an incentive structure to induce the increase in investment in order to get universal service. 8 million Brazilians do not have access to bathrooms. So to put the question in a very simple and blunt manner, that tells you about the health impacts of this kind of problem in infrastructure. So here we have the map of Brazil in an illustration of the situation in terms of water losses. This is another problem, again referring to the previous presentation, which was very, very good, about efficiency. How important it is to increase efficiency in providing services which are essential to the public. When we say that we have more than 40% of losses here, this is a real problem. At the moment, public companies are not very efficient. So this poses a real problem for the country. Also, the tax structure is particularly perverse. We tax water and sanitation services. If we calculate the positive externalities of those services, we should be subsidizing this type of service. Instead, we are taxing heavily these services. So there is a real problem in terms of the tax structure. The public sector is very important for providing those services. Each state has a public company that in the past had the monopoly in the state area, and nowadays there is a competition with the private sector. But still, state companies represent approximately 70% of the market in water and sanitation in Brazil. So this here you have the market shares. The state companies represent 70%. You have municipal companies, either what we call in Brazil autarky, so they are relatively autonomous departments of the municipal administrations, or independent municipal companies, but owned by the local government. So they represent around 24%. And the private sector is increasing its share. So one interesting debate is whether this competition with the private sector is going to increase efficiency or not. So I find that this competition is healthy. It's a good ingredient that is going to increase the quality and the quantity of the services. So this is, I think, an interesting debate, but of course this is quite debatable. Many people would say that no, the private sector should not enter this market, or there are some more liberal views that would say, no, you should privatize all state companies and the private sector will provide much better services, and you should treat this market as a regular, normal market. So I would have an intermediary position. I would say that the state will always be very important in the sector, and public-private partnerships are quite useful in this particular sector, and could increase efficiency in trying to conciliate the search for profit on the one hand, and the search for activities which will pay investors, and also the goal of having universal services. So this conciliation is not trivial, but I think that it's possible. The company I worked for during 2007-2010 is an example of a public-private partnership. It's owned by the state of São Paulo. Slightly more than half of the shares are owned by the state of São Paulo, and the rest of the shares are in what we call the Novo Mercado in São Paulo, in the stock market, in São Paulo stock market, and the rest is in the New York stock market. So it's a company that has some public goals of providing universal services, and at the same time has to make profit in order to pay the investment that investors make. And I think that the performances, of course I'm suspect to say that, but I think that the performance is relatively good. So it's a good example of a public-private partnership. And there are other modalities which we could discuss later on. It's also important to say that this company as a public company in Brazil has to respect competition law. So it also competes with other companies and has to obey the competition rules. Here you have a general view of 5 states that have more than one private concession. So the private sector is increasing its presence in a few states. It's the market shares is still small, but it's increasing. We are increasing the coverage both in water and in sewage. But the problem with the sewage coverage is still very serious indeed. If you see some states in the north of Brazil, this is the state of Pará, this is Rondônia, in Amapá, Piauí. So those are states with less than 10% of coverage in wastewater treatment. So this is a very, very serious health problem. And with the GDP per capita that Brazil has, this is a problem. This is totally off the line. So Brazil has the material conditions to have universal service in water and sanitation, but we are still far from reaching the goal. Here we calculated how much we would have, when we would have universal service if we maintain the current investment levels. We would only have universal services in the year 2060. So that would be a shame to have that problem. I find that other countries in the world also, other emerging economies in the world also have this crucial problem. And I think that the competition problems are very, very important to cope with those problems. I think that competition authorities should think about their role in stimulating investment and stimulating getting a better performance in those markets. What we have to do, we have to increase investment. If we increase investment, we could reach universal services by 2031. But the best would be to do 2 things. double the current investment level and increase productivity. So there is also a problem of efficiency. And we see that if we do that, by the year 2024, we would have universal services. So this shows how important it is to increase investment and increase efficiency. And needless to say, the impact of sanitation services on child mortality, on health, are enormous. You can see this line of infant child mortality, which is clearly negatively correlated with the increase in coverage of water and sewerage services. So this is what I wanted to say about water and sanitation. Some regulatory aspects which are interesting. This design that Brazil has was made in the 70s, and it was decided that each state should have its own company. It was that worked in the beginning. The companies increased investment. The situation was much worse. But more recently, we see that, as we illustrated before, most state companies are in a difficult financial situation. So they do not have the necessary capacity to invest, and they do not have capacity to borrow in the capital markets. So because they have awful results. Therefore, you don't see enough investment capacity to cope with the problems of universal services. So you really have a problem there. And if you see the division of labor in terms of planning, regulation, and implementation, as I said before, the three levels of government are very important. The federal government is important in planning through the ministry, the so-called Ministry of Cities. The state is quite important because we have state regulatory agencies, and the state companies, as we said before, provide 70% of the services. And also the local governments are quite important. So part of the problem of investment resides in this very complex regulatory framework in different levels of government. This very often creates a lot of uncertainty in terms of long-term investment, and that tends to diminish the amount of investment that is made by the private sector. So this is one problem. And you have to add to this the competition authorities. Any kind of competition problem you may have here can also be dealt with the competition authorities, the federal competition authorities, especially CADE, which is our major competition authority. So it can be quite complex. What has changed in the recent times in this regulatory framework? And this is quite interesting, and I think that it will be the trend in Latin America. There are some interesting changes. First, there was self-regulation. The company I worked for, people, the Sabesp employees, were not used to having a regulator. The company, the monopoly, would make the regulation itself. In the first rules, people were very surprised. Said, well, why do I have to obey this? You know, this regulator doesn't understand anything about water services. I said, well, you better obey, otherwise we will have a big fine, and so on and so forth. So there is need for a new culture of external regulations instead of self-regulation. Another problem is that in the past there was a great focus on engineering works, and this you can find in most segments of infrastructure. There is not enough emphasis on the customer. I mean, nobody cares about the customer. I mean, my colleagues would be very concerned about the technicalities and about the very nice equipment that was obtained. And it's very good that they are concerned about that. But there was not focus on the customer. I would dare say that you can find in many, many other emerging economies. Our colleague from India may confirm that. I was recently in the state of Uttarakhand in India to observe the design of sanitation services. And I found there many, many similarities with our experience in Brazil. I was also in Bangladesh observing the services of Dakawasa. And also you find that usually it's a company of engineers, and they do not think about the customer, the focus on the customer. And in Brazil, if you observe telecommunications, Professor Paul, it's disastrous the way that the telephone companies treat the consumers. I mean, there is no concern about the quality of the call centers, for instance. I mean, the worst thing that can happen to a consumer is to have to ask a question to a telephone company. That's a major problem. You better not ask. So if the telephone is working, just go on. Don't ask anything, because otherwise they might cut your line. So this is a major problem, and I think competition authorities have a lot to do with that, in the sense that they have to design mechanisms to stimulate competition, which will lead to better services in the regulated markets. So this is something that would be very, very important. In what we are seeing in the recent times are new areas, many, many new areas, and they are crucial not only to health, but also crucial to environment. So there are many, many economies of scope with other sectors like energy, waste disposal, generation of energy from waste disposal, and so on and so forth, that can be developed. So the water and sanitation market has to be thought in a totally different way, as a means of stimulating environmental solutions. So water companies do not sell water, they sell environmental solutions. And this has to be thought in this way. When we think in this way, we have to see the market in a totally different framework. Here you have the many, many state regulators. So many states in Brazil are beginning to develop external regulations. So so if you are a company if you operate in several states, you have to obey to relatively different regulations within the federation, which can be quite complex. And finally, sorry if I'm taking too long, finally, I would like to talk about some competition aspects of this sector. I would like to call your attention to competition within concession. Because sometimes we think, well, those companies are monopolies in certain territories. That's not true. Because since the market is not only water and sewerage services, but many other services, and there are other sources, you have competition within a same concession. Second, competition within municipalities in alternative sources are very, very important. And when you have informal markets, this becomes even more complex. And finally, we will talk a little bit about benchmark competition. So let me talk about, let me go a little faster and remind you that you already have different public public-private partnerships. And let me tell you about the experience of Sabesp competing with other water providers. So what was happening in the municipality of São Paulo was that Sabesp was losing many clients. So it had the concession of the municipality, but it was losing clients. And this was happening because other sources of water, underground water, was being provided. And also some industries were resorting to water that was brought by trucks. So you can see in the city of São Paulo many trucks carrying water to very many places, which is quite inefficient. But you can see that because in many cases, those people do not pay taxes. So they are in the informal, in the underground economy. Sometimes they use underground water, but sometimes they use the normal surface water, but they are in the underground economy. And when problems like this go to competition authorities, very often you see someone in the competition commission saying, well, this is a very interesting problem. There is indeed a problem of unfair competition, but it's not my jurisdiction because this is a regulated sector. What I would like to call your attention that this is absurd. Competition authorities should look closely into the details of the regulated markets, especially in emerging economies, in transition economies, where you frequently have many problems with the underground economy, in order to see the competition impacts of the informal, the underground economy. So there was clearly a competition effect. So you were losing clients, and the competition authority would not see the problem. But it's necessary also to take into account more flexible regulatory rules. Let me give you the example here. We calculated the probability of losing a client after a certain amount of water. So we tried to show the local regulator that if the regulatory agency would have a more flexible norm, we would not have this problem. So two things. Regulators should be very should look very closely to this type of distortions, and competition authorities should participate in this process. So this was a point that was very important for us. And in Sabesp, which was monopoly, went to the authority and begged to compete. So and to reduce price. So what Sabesp wanted to do was to give price discounts in order to compete with competitors which were taking clients from Sabesp. So I thought this would be useful for our reflection. I will not go into the technicalities of the numbers that we took to the regulators. Also, environmental solutions are important, but in summary, I would say that one has to take into account competition within the concession, as I pointed out, in the competition that public companies have with private companies and with the municipal companies to conquer a concession. So I find that in many sectors, especially infrastructure sectors, it is a good idea to have public companies that have public goals, but at the same time allow competition with the private sector and allow for several modalities of public-private partnerships. I think that in many economies, we would increase investment and increase the quality of services if we would allow for this type of competition. So we would have some kind of benchmark competition. Also, I find in the public sector in general that there's a lot to do in terms of designing the tenders, using competition concepts that increases enormously the degree of competition, and also that helps to reduce costs and increase efficiency of those companies. Also, we had a good experience in this public company having special agreements with competition authorities. I think that competition authorities can help enormously public companies to design the tenders, to identify markets where there are cartels which harm public companies and of course the public in general. So I think that there's a lot to do in terms of cooperation agreements between competition authorities and state companies in general. And unfortunately, I do not see many agreements of this type happening in practice. So I think that this should be stimulated much more in all emerging economies, in all economies in general. I think that the tax structure is very often the reason why you do not have uniform tax treatment, and you have a number of negative competition consequences. So it's another topic that one should take into account. So I would say that competition authorities should be a lot more intrusive, that they should make many more recommendations, should participate more in regulated markets, should not have a position of, well, if it's a regulated market, I will not participate. I think that there should be a proactive attitude towards the regulated markets, and public companies and the public sector in general should resort to competition authorities in order to increase efficiency, and should not fear competition. I think that the presence of the private sector or different types of public-private partnerships are good. They give benchmarks and they increase efficiency, and that gives a better allocation of resources and at the end a better level of satisfaction to consumers. Thank you very much.
Two comments left. The first will be delivered by Professor Tania Zuniga. Professor Zuniga achieved a law degree in Peru. She went on with graduate studies in Germany, where she earned a Master of Laws degree at the University of Heidelberg, as well as a doctorate at the university, the Humboldt University in Berlin. And nowadays, she is a professor of law at the Catholic University of Peru. Would you like to speak from your place? Okay.
So the Spanish experience is generally considered as a relevant perspective for the Peruvian legislative and case law practice in Peru. As we have seen by the colleague Marcos' presentations, Article 4 from the Spanish Competition Act establishes a limit for the competition authority concerning antitrust law implementation. Article 4 provides that anti-competitive conducts are not a subject matter of sanction, where such conducts resulted from implementation of a law. Such anti-competitive conducts are not unlawful. It is important to highlight that the Competition Act is not only a limit or a barrier for repression of anti-competitive conducts by allowing the legal exemption of a sanction. The law demands that the exemption of sanction should fulfill the requirement of the existence of a previous law issued by the legislator involving the responsibility exemption. In other words, a cause for responsibility exemptions may not be introduced outside this scheme. However, there is still the question, what happens if under the basis of an administrative act or regulation, the companies commit any anti-competitive conduct or act? Article 4 only provides the exemption in case it comes from a rule with the character of law and does not accept rules with infralegal character. In this case, companies will be between a rock and a hard place, because companies perform in accordance with a legal rule from the legal system, therefore their conduct is legal. Nevertheless, companies could be sanctioned according to Article 4. Precisely, in this matter, I would like to refer to what happens in Peru. The legislative decree number 1034, this is the Repression of Anti-Competitive Conduct Act, provides by Article 3 as follows. This law does not apply to any conduct that is a consequence of the provisions in a legal regulation. Such regulation will be disputed through the corresponding means and not before the competition authority stated in this law. The state shall be able to take actions it deems necessary to contribute to improving the conditions of the supply of products for the consumer's sake. However, the competition authority can discretionarily issue reports related to the conducts referred by the preceding paragraph in order to assess their effects on free competition and consumer welfare. So the objective of this normative is clearly stated in the explanatory statement in order to clarify that only a rule with character of a law can establish an exemption to the prohibition and sanction of anti-competitive practices. As in the Spanish case, the incorporation of legal exemption in Peruvian antitrust legislation does not respond to an attempt of restriction for implementation and effectiveness of antitrust legislation. On the contrary, it responds to the purpose of avoiding the state action, gives immunity to private economic agents for performing anti-competitive practices. Back to the question, what should a company make in case a regulation or an administrative act following performing a conduct that could infringe the legislative decree number 1034? No? To answer that question, we can distinguish two assumptions. Assumption number one, when a sub-legal rule or a public administration act allows or promotes a conduct which could be qualified as anti-competitive. Assumption number two, when a sub-legal rule or a public administration act imposes a mandate of action which could be considered as anti-competitive. In both cases, the company knows that it does not have antitrust immunity under Article 3, since those rules do not have character of law. This distinction is very important because it allows us to observe the scope of action of an economic agent in relation to exercise of public authority. In the first case, there is a scope of action for the company, but the company is not obliged to do something. It only represents an option for the company. If it does so, it would consistently assume that the competition authority may qualify the conduct as anti-competitive and sanction the company. In this case, there is no exemption of the sanction to the sanction. In the second case, the situation varies since it is about imposing a specific conduct. The non-fulfillment of this obligation may imply a sanction as a negative consequence. On the other hand, the non-fulfillment of such mandate could give rise to the beginning of a sanction procedure before the competition authority, and could end with the imposition of a fine if the authority qualifies as a competitive conduct prohibited by the competition law. On the other hand, since the point of view of legal certainty, the authority could also decide to admit the exemption of antitrust responsibility. In this way, the economic agents shall not have the sanction. In Spain, authors such as Samburini or Rebollo have highlighted that the lack of will, intention, or volition from companies at the moment of the anti-competitive conduct should lead to the exemption of responsibility. So I would like to refer to an important case in this moment in which legal responsibility could be exempted. The case Ferrocarril Santuario versus Ferrocarril Transandino was ruled in 2006. So you have, as we can see, that's an important case and located in the Turin's branch. Cusco is our treasure in Peru, so there are obviously main interests about management of the Peruvian trail. And so, through a concession agreement, Ferrocarril Transandino, FETRANS, is responsible for the administration of Ferrocarril Sur Oriente. Under this contract, such companies also obtain the right to exploit the rolling stock and track material given in concession. FETRANS leased exclusively to its related company, Peru Rail, opposing this exclusivity to the competitor company, Ferrocarril Santuario Inca Machu Picchu, Ferrosimsac, that requested to lease a part of this rolling stock and track material. As a result of this, Ferrosimsac, so the competitor company, filed a complaint against FETRANS due to the refusal to lease the rolling stock and track material, being such complaint justified in this alleged exclusivity allowed by the concession contract. The Free Competition or the Free Competition Commission of Indecopi dismissed the complaint against FETRANS since it understood that the concession contract supported the exclusivity granted to Peru Trail. Understood that the refusal was actually the regular exercise of a right supported by the concession contract. By contrast, the Administrative Tribunal of Indecopi in the second instance, by the Authority of Competition, interpreted that the concession agreement did not grant such company the exclusivity in the use of the rolling stock and the track material, and thus this refusal exclusively sustained on the provisions of the contract was unjustified. The situation was assessed in the light of the previous law of Peruvian competence, Legislative Decree number 701. The tribunal analyzed whether the concession contract covered or not the adoption of a conduct that might be considered as anti-competitive and will be exempted from sanction. So in this case, a public provision might exempt a company from a sanction. In its original version from this decree, 701 contained a regimen of authorization of competition restrictive practices, but it was a scheme of particular exemptions in favor of the party requesting and obtaining such authorization. There was not a general exemption scheme of a set of conducts or a group of an economic sector. There was just only one mandatory precedent which clarified the assessment criteria, such as if certain exceptions promote or not the technical or economic progress for the consumer's welfare. This regime was eliminated by the legislative decree currently in force 1034 in 2008 by the Article 3 that regulates particularly the legal exemption. In contrast of the Spanish practice, we may state that in few disputes where legal exemptions have been alleged, the normative hierarchy or status of the state activity has not been analyzed, either legal norm or act. Under these considerations, by the reasoning in the Veterans case in the copy, first accepted the possibility of sanction exemption when it is an act resulting from a contract with the state. Unfortunately, the administrative tribunal does not accept. A contract, even it has been entered into with the state, does not mean that it could exempt the fulfillment of a rule with character of a law. Contracts must respect what is foreseen by law, and obviously any contract provision against to the law is null. However, the situation in the case of administration acts is not simple in practice. In the event of a government intervention, and economic agents could support the need to implement the rules of competitive to the public officials who participate in these practices. From the theoretical perspective, economic agents should reject any proposal from public officials or political authorities intended to limit the free competition. What is true is that there is a relationship of undeniable dependence and hierarchical fear that compromise sometimes the survival of entrepreneurs on the market, depending on the greater or minor degree of power of the official or politician, likewise their rationality in exercising such power. This problem can occur not only in Peru, caused by corruption indices present in some public entities. We agree with colleague Marcus that the relevance of this liability exemption is real, since experience shows that whilst the competition defense measures increase, multiplying the procedures and sanctions, companies, for its part, make an effort to achieve that anti-competitive practice or restrictions to the free competition are introduced or incorporated into legal rules or public interventions in order to avoid the application of sanctions. The same perspective is stated by Merz, like my colleague Francisco Marcos has referred, warns about the advantage that individuals find in obtaining public restrictions on competition that protect or provides validity to private cartels. In Peru, we also find this concern. If a broad interpretation of section or article 3rd of the law is accepted, it could generate perverse effects. The problem is what the concept of legal rule of section 2nd of this law should comprise, since it could mean accepting that every minister, general director, superintendent, regional president, mayor, or other authority authorized to issue an administrative regulation may authorize a company to abuse its dominant position, for instance, or enable several companies to make a collusive practice. According to the jurisprudence of the Constitutional Court in Peru, within the concept of legal rules are, in addition to laws enacted by Parliament, treaties, regulation of Congress, legislative decrees, emergency decrees, regional ordinance, and municipal ordinance. However, the Constitution of Peru stipulates that Peru is a decentralized and unitary state. The Constitutional Court, in accordance with the Section 43 of the Constitution, has stated that the regional and local governments are power bodies territorially delimited to which political, financial, and administrative autonomy are given, but its exercise should be made according to the provisions of the Constitution and the laws governing the competition framework of regional and municipal governments. It seems that in Peru, to the extent that free competition informs growth, incentives of the companies seeking for more effective tools to limit the competition will also grow. It has been suggested that paradoxically the state, whilst promoting free competition, is in turn its main enemy. So, for concluding these remarks about the topic exemption, legal exemption, I would like to conclude that there will be cases by market failures where the intervention of the state is needed. In such cases, the state should assume the competition advocacy properly, exercise it, in order to achieve these objectives stated in the constitutional order. So, if I have time, I would like to make...
I'm afraid we don't have to be very frank, because we are in delay already.
Delayed, yeah. Just, just 1 minute?
1 minute, okay.
So I wanted to make a remark, but
1 minute is a minute, okay?
Yes. According to the Constitution, because this is a very particular statement in our constitutional order, it is expressly stated that in the political, in 2 articles in the constitutional, political constitution of Peru, seeks to limit the performance of the state in the economy, claiming that the primary role of the state in a social market economy is to stimulate the generation of wealth through the promotion of private investment, as well as to guarantee economic rights and freedoms. But there is a limit imposed to the state to exercise business activities. This is Article 58. And with the exemption of sectors where the private activity is either non-existent or insufficient, reflecting the principle of subsidiarity of the state. The state cannot participate freely in the economic activity, but only subject to the subsidiarity, which should be understood as a market oversight, corrective and regulatory role.
Simonetta Vezzoso pursued law studies and graduated at the University of Milan in Italy. She holds a doctorate in economics of a German university, of the University of Witten-Herdecke. She is a faculty member at the University of Trento in Italy, and her research focuses on competition law as well as on intellectual property. We are curiously waiting for your comments.
I think that this conference is proving once again the remarkable nature of ASCOLA as a format for academia and beyond, of course, to discuss antitrust competition issues in a truly international dimension. I really enjoyed the previous interventions, and perhaps in particular the fact that from competition we moved to fundamental rights and then back. The topics discussed on this panel, similarly to Spain, has been very hot in Italy in the last months. The Italian Competition Authority got also its stick as recently as the end of 2011, and very similar, perhaps to the Spanish Competition Authority already for some time, Italy has a very good season. I would call it perhaps summer or autumn of competition policy in Italy. And also, the Italian Competition Authority very recently got a very nice carrot as well. So actually, it is a very, very nice time for competition authority at this moment. Of course, you know why, because we have the Prime Minister, the wonderful Prime Minister we have nowadays was the former EU Competition Commissioner, and of course, the Italian Competition Authority is going to profit quite a lot from this wonderful season. It's not going to last very long, I'm afraid. Of course, since taking power in November 2011, the strategy pursued by Mr. Monti had one main objective, of course, not be surprised, to get Italy out of the danger zone, and two main pillars. On the one side, to speed up fiscal consolidation. On the other side, of course, promote economic growth. Therefore, the task of removing the remaining obstacles to liberalization ranks particularly high on the government agenda. Despite huge popular support, the government succeeded in having only part of its reform proposal turned into law on March 24th last. Well, of course, this might have to do with the so-called technical nature of our new government, but okay, we cannot discuss it further. Perhaps the most remarkable achievement of Mr. Monti's government so far concerns local public services. In Italy, local authorities have significant regulatory powers in areas such as, for instance, transport, water, energy, and so forth. The provision of those services in Italy, as perhaps not only in Italy, has been very often monopolistic, in-house or not in-house. According to the new law, public authorities should not be allowed to give an exclusive concession for the provision of services unless they have verified through a market analysis that the services cannot be provided under competitive conditions. The local authority's decision to grant an exclusive concession will have to be submitted to the Italian Competition Authority that will have to issue a public, albeit not binding opinion. But still, it's quite a success. However, very important economic sectors have been partially or totally exempted from the application of these rules. For instance, water, for instance, energy, but still, transportation is still part of the reform. Well, apart from the area of sector-specific regulation, I find the topic discussed here today on this panel particularly intriguing, because once you start focusing on state-induced constraints on market behavior or market structures, you see them everywhere in the so-called market economy, as has already been remarked on the previous panel. Perhaps we should soberly interpret these as a sign of maturity, perhaps, but I'm not sure. Paul just talked about the concept of universal service as spanning across economic sectors. A good example of regulation applicable to all sectors is the legislation on intellectual property that will be discussed as from the perspective of state-initiated restraints of competition on the next panel. Well, as usual, you might imagine, commentators get the panelists' presentations on the way to the airport, on the way to the central stations, if you live in Central Europe at least. Well, anticipating this, Joseph and Vicente gave us the freedom and opportunity to choose the perspective we most cherish and perhaps connects to our actual research topic. And I definitely took this opportunity. I'd like to talk very briefly of pro-competitive data consumer regulation. I promise to stick to the, 7 minutes by now, something like that. Okay, so consumer data protection regulation is traditionally applicable to a large number of economic sectors: health services, insurance, telecommunications. In the last 20 or so years, data protection regulation has become particularly relevant to the information and communication technology sector. There is a clear trend on both sides of the Atlantic, north or south, toward allowing a more intensive use of digital data in general, with a view at achieving economic benefits. The OECD recently described digital data, personal data, as the basic currency of information economy. Well, this morning, Joseph talked about one significant aspect of this trend, of course, that is the reuse of public sector information in the EU. By a sort of innovation in our narrative, we could start considering legislation protecting online consumer data as an essential part of the regulation of the ICT sector. In this respect, it becomes apparent that the relationship with competition policy, while often complementary, can occasionally become rather tensed, as I'll try to highlight in the last few minutes, I promise, of my comments. Well, the European Commission, as the so-called guardian of the treaties, is competent in both areas of competition policy and data protection. In this respect, its position is not dissimilar to that of the US Federal Trade Commission. As commonly acknowledged, data protection regulation could be a useful complement to competition policy. For instance, let's take the right of data portability. Well, we could apply that concept of a number portability we know from the telecom sector. We could take, for example, a right to data portability, already similarly well known in the telecom sector, and we'll of course consider it as a perhaps very useful complement to competition policy. And this is actually part of the package, the newer EU data protection reform package, which was announced by the Commission during a LAPSI conference in January this year. Still, there could be some tension between competition policy and data protection regulation. But those tensions perhaps are not self-apparent. In fact, competition policy could be seen as somehow quite naturally incorporating the goal of protecting consumer privacy. This issue was discussed, for instance, in the US in connection with the Google DoubleClick merger. During the discussions which have accompanied the approval of that merger, it was held by FTC Commissioner that a merger must be examined for its negative potential effects on all dimensions of competition, not only price effects, but also including privacy. Well, the assumption here would be that, for instance, social networking sites like Facebook compete to offer the most complete, comprehensive form of privacy to its user. Well, as you know, reality shows that market incentives, at least for now, stay quite differently. Social networking sites do not compete in the protection of personal information, but in its acquisition and monetization, which is quite different. In this respect, obligations of privacy by design or privacy by default could be seen as possible remedies to a market failure. On a different note, and this is my very last comment, I promise, the question can be posed whether privacy protection itself can become a barrier to entry. For instance, let's take Apple. It's a closed platform, single undertaking, having the sole control over user data. Well, this power, this very, very impressive power, could be somehow leveraged to hamper or eliminate competition in related markets, such as, for instance, mobile advertisement or application development. In this respect, a data supervisory authority enforcing a high level of protection on a successful undertaking could possibly come into conflict with the competition authorities' enforcement, for instance, of an abuse of dominant position. Well, as FTC Commissioner Roche recently put it, an issue we will likely face on the horizon is what to do when high-tech firms start using the need to protect consumers' privacy as a defense to an antitrust claim. Well, and he admitted that he didn't know the answer yet. Well, from a European perspective, the answer might be somewhat clearer. The Court of Justice stated in numerous occasions that the regulated conduct defense is not permitted when the regulation merely encourages, makes easier, or authorizes the undertakings to engage in autonomous anti-competitive conduct. Going back to our privacy issues, the relevant question then would be, in an abuse of dominant position case, whether despite data protection regulation that encourages, authorizes, or even imposes strict privacy measures, there is still room for autonomous conduct by the dominant undertaking. Of course, this could remind you of other cases like Telefonica, etc., just dealing with that. Well, there is but an important caveat, and then we go back to the fundamental rights issues. Data protection in the EU in the post-Lisbon Treaty era has the indisputable legal status of a fundamental right. The constitutional nature of the commitment to undistorted competition is also beyond dispute. However, as you might know, that commitment has been removed from the preamble of the treaty and is now part of Protocol 27 annexed to the treaties. It can be argued that the clear recognition of fundamental rights by the Lisbon Treaty in conjunction with the downgrading of the requirement of undistorted competition to a protocol would stimulate a more holistic approach, perhaps, in the interpretation of competition law, in order to guarantee EU-protected fundamental rights, such as the right to privacy. To conclude, pro-competitive regulation can be seen as a snapshot, perhaps, on the way to a full competition regime. More frequently, however, regulation is there to stay and flourish, even in otherwise very dynamic economic sectors. As to data protection, it would be interesting to follow how, in the European Union as elsewhere, an appropriate balance between competition and other, at least as important values, such as privacy, will be achieved. Many thanks.